Good afternoon. I'm Patty Corrales, as many of you know, and welcome to my show, Justice Matters. Today, we're going to have a lively discussion. I have two amazing attorneys with me. I have Nora Phillips, who's an attorney who's practicing in Boyle Heights, and to my right, I have Liz Salinas from the Law Offices of Weiss. Ladies, thank you for coming on my show and welcome. And if you could, Nora, if you could introduce yourself to the community.
Sure. My name is Nora Phillips, and I'm a partner at Phillips and USCIS. We're a full-scope immigration law firm, and our office is located in Boyle Heights near First and State.
Thank you, Nora. And Liz, would you mind introducing yourself to the community?
Yes. Hi. Thank you, Patty. My name is Elizabeth Salinas. I'm an attorney at Weiss Immigration Law Group. We're in downtown Los Angeles, and we practice immigration defense, family-based immigration defense.
Well, ladies, we're going to talk about a number of things, but the first thing I want to talk about today is DAPA and the extended DACA. As you know, I believe on February 19th, the district court in Texas basically, just to make it very simple, said DAPA and extended DACA cannot go forward. He enjoined the government from proceeding with those two applications. Do we know anything about that since then, Liz?
Well, right now it's still enjoined, and that means that we don't know what's going to happen with the program. It's being litigated. And one thing that we want to make sure that the community knows is to be very careful about anybody trying to go to an attorney or a notario or someone who wants to take money for a service for a program that's not yet in effect. So you have to be very careful. Recommendation is for people to still actively collect all their documents, their physical presence, any and all documents that they have for when eventually, if the program does go in effect, you can hit the ground running. But for right now, there is no DAPA or extended DACA that's actually going on.
Thank you, Liz. And I think that's important for the community to understand, because there are many people out there who still are saying that you can apply when you really can't. Nora, do we have any idea when there will be a decision? And what, if anything, what if a decision comes down a couple months before the president has to leave office? What effect will that have? Because I have so many people who come to my office and say, abogada, what happens if the court, the higher court, rules that the district court judge was wrong in enjoining the government from proceeding with DAPA and extended DACA, and 2 months later the president leaves? What happens?
Well, nobody really knows. I mean, that's the real issue, and it's very complex trying to explain to clients that it's not a law, DACA as we have it now, which does still exist. And that's also very important. There's been a lot of confusion about whether or not original DACA, for those who entered prior to age 16, who've been here since June 15th, 2012, or 2007 until now, that still exists. So people need to know that original DACA is still fine, good to go. You can still apply for it. As far as expanded DACA and DAPA, that's very, very problematic because it's not a law. So yeah, it is sort of contingent upon who's in the White House. And my advice to people, provided that they qualify for it, hypothetically speaking, let's say 2 months before the president leaves office, like you said, it exists. I'm going to tell every single person to go ahead and apply for it, unless it's too risky for them, or unless they don't qualify. Because I think that with these new remedies that are basically, because Congress is so dysfunctional and because of the massive anti-immigrant vitriol that we're seeing, unfortunately, I don't think that a change in the statute is going to be coming anytime soon. And so what we're left with are these administrative things that are sort of, tied to the presidential administration. But I think that it's really based on momentum, which is what we saw with DACA as well. The more people that have it, the more secure everybody is, because the more of a public relations disaster it's going to be if a new president takes office and decides to do mass deportations, which I don't think is going to happen.
And I'm glad you mentioned that. And Liz, I want you to talk, and I want to talk about the real issue why we're here today, but this is such an interesting issue. I mean, we can talk about it all day. Okay. It is difficult to explain to the clients that right now DACA, original DACA, as Nora talked about, still exists.
Yes.
But there are many who applied early on when after the president announced DAPA and Extended DACA in November, and I think it was November 20th, 2014, that when they renewed their DACA, they got the 3-year card.
Yes.
Many of them still do. Now, some of my clients got the 3 years, but then they got a nice little letter from the Department of Motor Vehicles indicating, oh, I'm sorry, but your license is no longer valid for 3 years. It goes back to your original 2 years. They received some sort of documentation from the DMV related to that. What have you been telling clients, and what do you think about, those who somehow caught the wave and haven't been told that otherwise that they no longer have the 3 years?
So I tend to be more conservative in my approach, and I want to protect the client. My view legally is that that 3rd year is part of the expansion that is enjoined right now. So I have some clients that have the 3rd year, and what I've been telling them is that 3rd year is questionable right now. That 3rd year is being litigated right now. So they have a card that has 3 years. Those first 2 years, well, obviously the president's next year will be elections, but I would just consider that 3rd year is up in the air right now as to what's going on. For all intents and purposes, I mean, they should calendar that, and I've calendared it, but I'm really looking at the 2 before the 2nd year expires with them and treating it as a regular DACA.
I agree. I'm also treating it as a regular DACA so that at 2 years you can renew if we have that privilege to renew
Absolutely.
again. And I think Nora's correct. I mean, the fallout of any president who comes on board to all of a sudden end DACA, I can see a president not actually providing for DAPA, but DACA has been somewhat, institutionalized now for now going on 3 years. Okay, it's really hard to now take away that benefit. And let's not mistake something. Let's call a spade, but the government makes money off these applications.
Oh, of course they do.
And our government is always saying that we are running out of money, that we are in a deficit, that this is one way to give individuals who are worthy of DAPA to have an opportunity to stay in this country, work legally, obtain a driver's license legally, get a valid Social Security number and card, and contribute to our country.
And also to be able to have the ability to travel,
Yes.
which is, I think, to my own personal belief is that DACA doesn't go nearly far enough, and we need immigration reform, like complete immigration reform. But one of the benefits of DACA, for sure, is the ability to obtain advanced parole, and I think that that's huge. I mean, we see, all of us see all the time in our practice, people who are stuck between a rock and a hard place because their mom's dying in Mexico and they can leave to be with her, but then they can't come back.
Absolutely.
So I think, it is one of the fundamental principles of the UN Declaration of Human Rights is the ability to be able to travel freely. And I think that applies to people who aren't even, in permanent status here. So that's another huge benefit. But going back to what you were saying about actions of a future president, you also have to take into account the fact that this is probably the most sympathetic population within the immigrant community, or these dreamers that are fluent. People see them, people who might be anti-immigrant see them on the television. They're speaking fluent English. They're completely and utterly assimilated into American culture.
They're lawyers, they're scientists, they're engineers.
Of course. So I think that the anti-immigrant hatred, I think that it's like, I believe that we are a nation of immigrants, and that all immigrants and all people deserve respect. But I think that it's even harder for those who harbor these racist and, hate-filled feelings towards immigrants to the mass deportation of a bunch of very young adults, who many of whom have been, I think my youngest DACA came to the United States when she was 6 weeks old.
Absolutely.
So mass deportations of that subsection of the immigrant population, no way.
Well, what I want to do is I want to ask every congressman that's out there, particularly those congressmen who, have those Tea Party ideas that are extreme. Check your family history. I bet there's immigration in your family's history. So it's really, to me, it's a hypocrisy.
Unless you're
It's
Native
a complete
American, there
hypocrisy.
was.
Absolutely. So
My
I just
family
find
came
it
here without papers.
hypocritical of them to have this anti-immigrant
Yeah.
sentiment when they themselves are immigrants. But we can go on that.
We could go on for
on
days
that
about
issue
that.
as well. But let's talk about something that Nora just touched upon, because I want to make sure that our community really understands what you just said. If you get DACA, you can't necessarily travel with DACA. DACA gives you an employment authorization card, but you can't travel with that on your own
No.
or on that card itself. You have to apply for something that's called advanced parole. And if you're granted advanced parole, then you have that permission to leave that the government is giving you, permission to leave and permission to return to the United States. But without advanced parole, don't travel
No,
just on
please,
your
God, don't do that.
on your work authorization card,
No.
because that does not give you that ability.
So I've done a ton of advanced parole cases based on DACA, and thankfully to this day nobody's had any problems. I'm also pretty cautious. There are some people that so rule number 1, you cannot travel abroad until you have applied for and received advanced parole. Rule number 2, there are some people who shouldn't even be traveling on advanced parole.
Correct.
USCIS, who adjudicates these requests, they're not your lawyer. They're not going to advise you and say, oh, wait, you got caught at the border in 2001 and you have an expedited removal order. It might not be the best idea for you to travel. They're not going to tell you that. They might just go ahead and approve it. And then there's some, I don't know what your take on this, but if somebody has a final order, would you want them traveling abroad on advanced parole?
No,
I certainly
not at all.
wouldn't.
Because I think advanced parole in the document that our clients get, it says specifically that
Absolutely.
this is not
It's not a guarantee.
It's not a guarantee, and certainly it's not a right to admission.
Right, because and you have to understand as well that you've got USCIS approving this, but then once you return, you're subject to another layer of review by CBP once you're at the airport or at the border, and they could make another determination of inadmissibility and not let you back in. So unless you have a pretty clean case, I would recommend to the person not traveling on advanced parole.
I would just want.
That's good. No, but let's go ahead.
I was just going to add, and also under the guidance that's out there for DACA, it is really 3 categories under which you can travel, which is work-related, school, or humanitarian, which is pretty much the catch-all.
Yeah.
We've done various different kinds of DACA for humanitarian. Sometimes it's straightforward. Sometimes you get requests for evidence that the government wants more proof of why it is that you need to travel. But so it's not really just what I tell clients. It's not just, oh, I want to travel to travel. If it's on DACA, you have to really fall into these categories, or they're going to really take a look at your application and it could get
Excellent point. Excellent point, Liz. And I also wanted to stress the fact that what Nora said, and which we often forget, is USCIS can grant you advanced parole, but when you get to the border, that's a complete different agency that's making a different determination. Right. And so in those situations, I screen the client's case quite thoroughly, which I'm sure you ladies do as well. If there's any criminal background, I never recommend advanced parole at all, because you can get advanced parole and then be stuck.
Right.
So not a good idea.
And not even necessarily things that they got caught doing, but sort of, I don't want to say behavioral related, but sometimes even image related, unfortunately. If I have a client that's, especially a male client that's younger, that's covered in tattoos, I'm going to be really, really nervous about him traveling back through CBP.
Absolutely.
Because there is a lot of this, they can sort of the catch-all phrase of,
stereotyping?
gang member, yes.
They're stereotyping.
They're totally stereotyping.
They're stereotyping.
And the irony is pretty amazing because a large percentage of the Border Patrol folks have tattoos. So I just like to put that in there.
No, and that's good. But let's call it what it is. Yeah. There is a lot of racial profiling, and there is a lot of stereotyping.
Huge amount.
And that's part of the law enforcement, in their tools of law enforcement, if you will, their tool chest. That's one of them, or several of them. So they are permitted under the law to use that type of technique.
And I will add, it's the laziest too, because it doesn't require any thinking, any pulling a file. It's just looking at somebody.
You look like you're up to no good, which is ridiculous. But we don't want to scare people out of applying for advanced parole either. No. It's not, you just need to go with an attorney who knows what they're doing, who's done these cases before, not a notario, never a notario, and somebody who specializes in immigration, and just tell them everything. And then if they determine it's always a balance of risk, there's any attorney that tells you that for sure you're going to be able to come back in is lying.
Absolutely. I love it when my clients always want me to give them, some sort of a percentage. Yes. Is it a 50% shot? Is it a 90% shot? When I was in the DA's office, they'd always ask me what my conviction rate, 90%, 100%. Everything is really a chance. I mean, it depends on how persuasive your case is, but I can never give a percentage. I never will.
And as attorneys, when they ask that question for me, well, I don't know if this happens to you, but when a client asks what's the percent I'm going to win my case or something like that, there's always a percentage that immediately pops into my head, but I'm not going to tell the client that because I don't want. It's just the way my brain works. I'm like 92, but I'm not going to. But I'm not going to tell the client that because I don't. I don't want. What I would much prefer is for my clients to be pleasantly surprised.
Yeah, absolutely.
I'm not going to tell them. First of all, I only take cases that I think are meritorious and that are going to win, and I'm very successful with my cases. But also, I don't want to. I would much rather be incredibly guardedly optimistic than say, of course you're going to win, of course you're going to come back, and then have the client be devastated if it doesn't work out.
Absolutely. I never tell clients any kind of percentages. What I tell them is I'll work 100% for you.
That's right.
There we go.
That's
I'll
a percentage.
work 100%
That's
for
a percent that
you,
works.
and I'll work hard.
Yeah.
But let's talk about. Well, we came here to talk about how you can adjust in the United States, and what I mean by that is how can you become a lawful permanent resident in the United States what avenues are available to you. And before we get to that subject, because it's another different subject, let's just tie up a little bit of the DAPA and the extended DACA. As Liz, as you mentioned, right now everything's been kind of stopped. It's been enjoined. Nothing's going forward with DAPA and extended DACA, but that doesn't mean that you should sit with your hands tied and not do anything. That you can start gathering documents to establish your residence from January 1st, 2010 to the day you apply. Is that right?
Correct.
And certainly don't have to pay a lawyer for that.
No.
You can do it yourself. Any document that has your name and a date that establishes that that document was generated here in the United States, right?
Yeah, and making sure you have your birth certificate
For the children.
Yeah, and if there's potentially any crimes that I would go to the court and get your certified copy of your disposition for any issues.
Unless you have a warrant, and then don't.
And unless you have a warrant, then you should seek the counsel of an attorney before exposing yourself. But in reality, it's gathering all your documents. If you've been paying taxes all these years, pull out your tax returns. Really, it's just a matter of getting everything in line and getting prepared, and you're going to be one step ahead once this thing gets going.
Yeah, and if it gets going, fantastic. You're one step ahead. You don't need to pay anyone to gather your own documents. What I recommend to my clients is go to Staples, buy a couple of folders, label them 2010, 2011, 12, 13, 14, 15, and start putting your documents in those folders, and just from January to December. You can do that.
I would add two things. If you can't find all of your documents, don't despair. You might very well still qualify, though that case might be a little bit more complicated, and you might need an attorney to get really, really creative about, maybe the golden key in their case is going to be that they were amazing about taking their dog to the vet to get vaccinated.
That's right.
Absolutely.
So some cases are a lot more challenging, and there are clients for whom it is going to be really difficult for them because of literacy or language issues to call the phone company and get all of their backdated bills or something like that. So if you can't get all of your documents, don't despair. The second thing is that there are certain things that you might want to or need to pay for to get in order, particularly immigration records. So I don't think that it's a bad idea for clients to be going and getting consultations right now to prepare for DAPA. The service itself doesn't exist, but to request their records, to do a FOIA request from CBP, from ICE, from USCIS, to find out everything that's in there, I think that that's a very smart, proactive move, because those cases are taking a while.
Nora, you're absolutely correct, and I certainly don't want to discount that. That's absolutely part of the preparation. If you know you have issues with immigration because for whatever reason you applied through a notary years ago for a work permit that never came, then it might be a good idea to do the FOIA, to go to a lawyer, to get a consult, to make certain that there's nothing negative in your background that all of a sudden will just show up when you apply.
Or even helpful. We had a client who our only proof that she entered before she turned 16 was the fact that Border Patrol caught her at the border and let her in. So the results of her FOIA request from Border Patrol was the nail in the coffin that allowed her to apply for and be granted DACA.
That's wonderful, and that's a good point. So we're not here to say don't see a lawyer. See a lawyer, consult with them, but understand that the application itself is not ready, and it's not available for processing, so you can't apply at this moment. I want to touch on something Nora said, and then I promise, ladies, we're going to get to our topic, and that is, if you have a criminal case, you have DUIs, that is something that they have made absolutely clear before DAPA was enjoined and before extended DACA was enjoined, that if you have a DUI, you're just not going to be eligible. They consider that a significant misdemeanor. Now, that doesn't mean you should just say, oh, well, I can't apply. No, what it means is see if you can get that DUI expunged.
That's right.
And so for those criminal-related reasons, there is a reason for you to go see a lawyer and consult with a lawyer so that you can see what that lawyer can do to either assist you in your criminal case or whether there's anything that can be done in that criminal case. So I'm glad you brought that up. Yes, still consult with a lawyer, but there is no application for you to process at this moment. Now, going back to what we wanted to talk about, if you can, tell us a little bit about how a person can immigrate to the United States.
Okay, so I like to describe it as a mountain called Monte Mica. So imagine a giant mountain with a green card on top. And there are like a million different paths. And some of them are really rocky, and there's no water, and there are snakes. And some of them are more like a very steep and kind of slow escalator. There are a ton of different paths. Each path has its own obstacles, its own eligibility criteria, its own waivers. And it gets really, 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 really confusing. But there are some, general categories to getting to that end result of the green card. And then after that, it's much more uniform to how to get to citizenship. So you can do it through a family-based petition. Somebody in your family petitions you. You can do it through an employment-based petition. An employer petitions you. You can do it through adjusting status as a result of having a certain type of visa for a certain number of years. You can also get it through asylum. So, for example, you have a fear of returning back home for whatever reason, you can apply for asylum. If you get asylum a year later, you can then apply for a green card. And then you can get a green card in court through certain things. So it's very, very complicated, which is why, again, I know I'm going to be a broken record about this. Very important to talk to a competent attorney to see how you can qualify. But through the family-based petitions and the employment petitions, it gets really complicated because a lot of people, there are two ways to get a green card. There's adjustment of status, which is where you do an interview here in the United States at a USCIS office, and you stay here. Or there's consular processing, where you have to leave the United States and go process through a U.S. consulate abroad. And those cases, for a number of reasons, financial and logistical, the least among them, are very, very, very risky because there's never a guarantee that you're going to come back in. And a lot of people, unfortunately, the way the immigration laws work is that if you have been here for more than a year illegally and then you leave, even to go to your consular interview, you then trigger a 10-year bar to reentry, and you're going to have to apply for a waiver for that based on extreme hardship to your spouse or parent. So it's very, very complicated.
Well, Liz, in talking about what Nora just said, we're going to talk a little bit about the family-based petitions. Mm-hmm. Now, as Nora mentioned, you can either consular process or you can remain in the United States to adjust your status through a family-based petition. But often you can't adjust your status in the United States unless you entered, first of all, when you first entered legally and you were inspected, or you are 245I protected. Correct. What other way can you adjust status in the United States, and can you talk about it? What I want to talk about is a little bit of what we know in our world of lawyers in the immigration community. A case called Quintalan. Can you describe it for us?
Yes.
And can you talk a little bit about it?
So it's a decision that came out about 5 years ago, Board of Immigration Appeals, that basically says the facts of that case, which are typical in Quilantan cases, is if you were, for example, the passenger in a vehicle and you came up to the port of entry and you made absolutely no false representation, you did not represent yourself to be a citizen, you were completely quiet, the officer saw you, you were in plain sight, you didn't engage in any conversation, the driver may have been the one talking, maybe the driver's a citizen and represented himself as such, but you were just visible but had no exchange with the officer. Then the officer permits you to come in with what's a wave through, and that's with your arm actually waving you in, then you have effectuated, under this case, your procedurally regular admission. So even though substantively you had nothing to prove, like no permission, no paper, no visa permitting you to enter, the fact that you came in, made no misrepresentation, were visible, and the officer allowed you with a wave through to come into the United States, then you have a lawful admission. And those cases,
and with a lawful admission, that individual can adjust status in the United States, correct?
Yes, it can within the United States, don't have to consular process, and that allows you to then, for example, if you're married to a U.S. citizen, now you can adjust and you have this lawful admission. The thing is, it's not as simple as it might appear, because it's a complicated thing. You have the burden of proof to establish your lawful admission, and the way that's done is through your testimony, and it has to be truthful, credible testimony. And if you have any corroborating evidence, typically in these scenarios, though, it's very difficult because in many of these cases, the person's coming in with the help of a coyote. And really, who are the witnesses to this type of a lawful entry? It's you, whoever was in the car, and the officer. Who knows who that officer is years later? Smuggling is a crime.
Right.
And it'll be very difficult to get anybody to come forth and be the one to put a sworn statement that they brought you in, because they're admitting it's alien smuggling. So it's really basically your testimony, and it has to be very detailed and credible, because you're going to be asked at your interview, you're going to be asked questions about the minutia of everything, how it is that you made this crossing, what color was the vehicle, what color uniform was the officer wearing? What time of day was it? Where were you sitting? What were the positions of everybody in that car? Where were they sitting in respect to the driver? It's very detailed. And even with your best declaration, there's no guarantee that the officer's going to believe you. There's no guarantee that your case will be approved. But if that was your situation, and in fact you were a passenger in a car, and I keep saying a car, but I've had cases where the person came on a plane.
Well, I've had cases where a person came on a plane as well.
Yes.
And they let them in. Now, and many of them walk as well through the line, and they don't necessarily are on the car. And the Border Patrol agents would do this nice waiver. It's like if they were on the Miss America pageant. Thank you. And they just wave them in.
And that's WAVE, W-A-V-E.
Yes, it's
yes. But let's just be careful and make certain that we tell our public that this type of entry, if you have this type of entry, you really need to talk to a lawyer. What kind of things does a lawyer need to do with a Quintalan case? And before I ask you, is a Quintalan case just available in California? That's one of the questions I often get. Or is that available in any state?
Well, it was a board decision, so it's available everywhere.
Okay.
Yes. Yeah.
And what sort of things should we be careful for?
Well, I think that with Quintalan cases, the most important thing is to grill your client like you're the immigration officer, because they're always with remedies, immigration applications where it's based almost where the only evidence is the client's word. Credibility is everything. So you're going to want to just absolutely interrogate your client for their own benefit about details and to try, and because if they're committing fraud, that's not a case that you're going to take.
Absolutely, and that's the problem with these cases is that sometimes it can lead to fraud. But I think Liz had a point. We have to be very detailed. We also have to do our homework. Yes. If our clients are telling us that they came in on a December 13th and they remember it was December 13th and it was a Sunday, and we check that year and it was a Tuesday, then we've got a problem, right?
Yeah.
I often in these Quintalan cases, although it's not necessary, I often recommend my clients go through a polygraph or a lie detector test, because if the lie detector test or examination comes back establishing forensically that they are telling the truth, that is corroborative evidence that my client's testimony is credible, and that the manner in which they came in is exactly the manner in which they came in.
Yeah, I think that's a wonderful idea. And I wanted to also mention, so it's not always the scenario that Elizabeth said. What if a client comes in, let's say, and this is extremely common for younger folks, comes in with a U.S. birth certificate. Unfortunately, coming in with a U.S. birth certificate is not going to make you eligible to do this under key lantern for 2 reasons. Well, first, false claim to U.S. citizenship, but if they're a minor, that's arguable that it wasn't misrepresented, that it wasn't. But more importantly, U.S. citizens are not subject to inspection.
Yes.
So it's basically the legal equivalent. If you're 20 and you're coming through with a fake U.S. passport, not only do you have the problem of lying and saying you're a citizen, which is punished very harshly under the immigration laws, but the legal effect of you coming in, let's say, as an adult with a U.S. passport and saying that you're a citizen is basically the legal equivalent of jumping over the border fence. You are not inspected, and therefore you're not eligible to adjust status under key lantern. And a large number of attorneys still don't seem to understand that, which is worrisome.
That's a good point. That's a good point. Yes. If you claim you're a U.S. citizen and you really weren't, you don't have a key lantern entry.
Not only
period.
because you lied and you're going to
Yes.
need but there's no waiver available.
But what you said, you are not inspected because U.S. citizens are not inspected.
No.
You
Period.
basically took away the right of the officer to even decide whether
Exactly.
they were going to inspect
Right.
you or not because
Absolutely.
you showed them you were a citizen. So
Correct.
But if somebody comes in with a fraudulent document, and let's say fake green card, or somebody else's green card, or a tourist visa that belonged to somebody else, and they make a misrepresentation, what's the effect of that? I mean, they would need to waive the misrepresentation.
They would
but
have to have a
been
waiver.
deemed admitted if they're able to prove that? I know that that's sort of up in the air.
that is up in the air, and I'll tell you, it's a very appropriate question because we have a case out right now, and that's
I'm
the
handling
situation.
one of those
It's
cases
the
as
same
well.
situation right now where we say entered key lantern but had a card,
Yeah.
so now we get an RFE for her to do a waiver.
I actually had one of those cases. I was in San Bernardino and doing an adjustment where my client unfortunately did use a false, someone else's green card to enter. But she was inspected, so I argued key lantern, applied for the waiver, the I-601, put together all the extreme hardship remedies, and I had a wonderful officer. There in USCIS, we are often critical of our government, those who are in the government who are handling these cases, and we have to be, okay, because these are people's lives on the line. What I just don't understand, and I can go off on another topic, is we treat immigration cases as just if they're civil, but they have such dire consequences on people's lives that the same protections that we give to those who are in the criminal arena, we should be giving to those who are in the immigration arena as well. But that aside, I had a wonderful, wonderful officer who understood key lantern, who understood that, okay, she entered key lantern but needs a waiver. And we were able to explain to her that the hardship, and she said, okay, this is going to be a good case. And fortunately for me, I had a very good officer, so I put together a good packet. And when I was surprised when I got an RFE. Why did I get an RFE? Well, they wanted more evidence of the hardship to the U.S. citizen husband. Okay, so I put together more hardship, sent it off, and then I get a denial. What's happening is USCIS is not, those cases are not going back to the same officer who initially handled the initial interview. They're going back to an independent supervisory officer or just a completely different individual. And then now they're trying to explain again the same issues that you explained in the first place.
That seems very problematic,
It is
especially
very
for
problematic.
a remedy like asylum or VAWA or U visa, where it really all is in the details and how you present yourself as a human being in that room with that officer. So those personal impressions that they made of the client when they're being interviewed are not then passed along to the person who's reviewing it. That
agree.
seems extraordinarily problematic.
Well, that's it's a new procedure, if you will, that USCIS is instituting. So if you maybe to avoid issues with an officer, I have no idea. But if you have an officer who does the initial interview and everything's going well, and then you get an RFE, that RFE is not going back to that same officer who handled that initial interview.
It seems like it would make the most sense to either have it go back to the initial officer or
course
to
it does.
Well, of course it does.
It's common sense.
No, yeah, but welcome to immigration law.
Yes.
Just common sense does not exist. But what could be a sort of a second preference for that would be to videotape the interview, so at least they could have the personal impressions of the person that they're
But here's the
interviewing.
thing. Here's the craziness of our immigration world. They're not going to interview on. They can't. They can't. They just do not have the equipment, the resource to interview, even to do a tape recording of your interview, unless you are a high-profile immigrant. you are on the national security watch list, and for some reason they want to interview, the government wants to interview. But if you ask for an interview, you yourself, because you want to make certain, no, you yourself want that interview recorded because for whatever reason you want to make sure your client's rights are protected, so that the second supervising adjudications officers gets to see exactly what happened.
So it
You're
sounds
not
like
gonna
what
get
you're
it.
telling me, Patty, is that I need to bring in my purple boombox the next time I have one of these cases.
What I found it frustrating that I was so close to an approval and then all of a sudden I got a denial. Well, you know, I appealed that denial and I put forth all that information that they wanted, and I'm like, well, wait a minute, we've got a due process issue here, because my client went through this whole interview process with an officer who judged her credibility, who was able to discern whether she was telling the truth or not, was able to ask the questions that were necessary, and now I have an officer who has no idea, is looking at things on paper and is denying my case. And he can't, there's no way that officer can judge credibility.
So in a case like that, how I would handle it is, you know, we all do this as attorneys. When we go to interviews, we take the most detailed notes, like where someone could just pick it up and read it, right? Then I transpose all of that into a sworn declaration. The best thing would be a recorded interview, but the second best is my notes, and I'm going to put it under penalty of perjury, and I'm going to highlight in my appeal that this officer had no questions about credibility. I mean, they had the opportunity to question him. They had the opportunity. I always, when I get RFEs on matter of key Lantan cases, I always go back to that recorded sworn statement. Some officers won't give it to you, though.
Yes.
And some will.
But here's the thing, you're entitled to it.
Exactly.
So if you're in there and you're in an interview and an officer does not want to give you that sworn statement, you go on and ask
to see the
supervisor because you're entitled to it.
So I had a supervisor tell me, if your client signed it, that's theirs, so they are entitled to it. But then I've had other officers tell me, you want it? Do a FOIA. Okay,
well, those are officers who are, being obstructionists.
Yeah. So what I do is actually, if my key Lantan case, I had my declaration, my client gave her testimony, we have a recorded sworn statement, I can prove that she's been consistent in her testimony. And she had the opportunity to be questioned by the officer. The officer made no negative findings. And then that's how I just really, really hammer that home, because it, like Nora said, it's all based on credibility.
It really is. It's based on a person's, the way they sit, the way they hold themselves, the way they talk, if they flinch. I mean, a lot of it is perception. A lot of it is, judging someone's, credibility. I think we can tell when someone's telling us a lie or someone's telling us the truth. And now you're going to tell me that a paper pusher is going to tell me my client is credible or not. And I disagree with that.
I think you're going to win.
Well, we'll see we'll see the outcome of that case. What I hope is good things for my client. Yeah. But I think we've come to a close, and I just wanted to thank you ladies for being here. Now, if there's anyone out there in the public who wants to get a hold of you, how can they reach you? I'm going to start with Liz. I
can be reached at area code 213-347-0025, or my email address is Elizabeth, ELIZABETH, at wilawgroup.com.
Thank you, Liz. And Nora, how can they reach you?
So I can be reached by phone at 323-300-5018, and my email is Nora, Nora, at phillipsurias.com, which is PHILLIPSURIAS.com.
Thank you, Nora. Thank you, Liz. Thank you, everyone, for joining me on my show, Justice Matters. If any of you have any questions, you can reach me at patricia.m.corrales@gmail.com, or you can contact me at 626-791-1434. Thank you.